When you have people in your life that you love and you care about, one of the most important things you can do is take steps today to help prepare your estate for that time when you will no longer be able to make decisions for yourself or when you pass. My guest here today is Mary Glenn. Mary is an estate planning attorney who has been helping families make those preparations since 2008. And we're very lucky to have her as a guest and also to have her as a member of Hargrave Family Law. And she's here today to talk with us about the essential things you must do to help prepare your family for that time that will come eventually. It's inevitable. Mary, thank you so much for taking time to be with us today.
Thank you for having me.
So when you and I first sat down to talk, I want you to tell us how you started to do estate planning.
Oh, well, so I started my law career in mostly real estate, working with a lot of title companies. And so I was reading a lot of wills because you do that when property is exchanging hands. There's a lot of wills to be read. And I always enjoyed it. And then there was a time when I had a change in my path and I had my first kiddo. And I decided, well, we need that. And my husband's an attorney too, but we thought, oh yeah, we need to have a will. So I wrote our will. It's funny, it's still the same will that we have today. And then I started thinking, well, other people need this too. And friends reached out and they thought, well, I need that too. Everybody I knew was having a baby. So, it's an important thing to have, especially with kids.
It really is. And I think it's easy for people to put it off because it can feel a little overwhelming. And so one of our goals today is to break down the process and really help people understand what are the documents that they need to have in place and what are the decisions that need to be made when preparing those documents. So let's talk about, first of all, let's talk about what happens when you don't have any documents in place, when you don't have a will or powers of attorney.
Sure. So obviously many people don't have a will. And I mean, that is a thing that happens. Texas has laws in place to take care of those people. So if you die without having a will, your unique circumstances and, your family dynamics are not taken into account. The Texas legislature has come up with a plan for you. So, and sometimes that's fine. I mean, if you have, just a very tiny little estate and a tiny little family, you have maybe one child and, or one husband or wife, that can be okay. But for the most part, we all have, a myriad of people in our lives. Sometimes you have blended families. The Texas legislature just really has it very simply laid out. And so it doesn't take into account any of your complications of your real life.
And really, in the estate planning process, it's a time to also clarify values. And so whatever values, whatever maybe, charitable organizations you wanted to help, provide assets for, like none of that gets taken into consideration.
No. And certainly too, if you are not married, or if you're just cohabitating, you can't leave, the Texas legislature, the state laws are not going to cover that situation. So basically, it just kind of, the way that the intestacy laws work is it flows through your normal family tree. So if you're single, it goes to your parents and then to your siblings, nieces and nephews. It kind of flows that direction. If you don't have those kinds of people, it keeps trickling down into, far away relatives, certainly just not maybe your friends or your charities or anybody else that you would want to consider leaving your assets in your estate too.
So you just use the word intestacy, and that's what applies. The laws of intestacy are what apply when somebody dies without a will.
Right.
And so with a will, as being probably one of the most basic estate planning documents, what is the purpose of the will and what does that help accomplish?
So the purpose of your will is certainly just to dispose of your probate assets upon your death, and you can list out your specific beneficiaries, Certainly, most people would say that they're going to their spouses or their children, but you can add in all sorts of things. You can do your estate. You can divide things evenly. You can divide things unevenly. Maybe you have a kid with special needs. They need something extra. And then you also decide who your fiduciaries are. So all of the people that you want to be actually managing your estate. If you don't do that, I mean, who knows who's going to step up and start messing with your stuff. So in your will, you can say who you want to be your executor, which is the person who manages your estate upon your death. And then if you have minor children, you can list people in your will that you want to be your guardian of your children, which is certainly important. And you can have alternates to all of these people and stuff, but it's important to make sure that your wishes are known and that you've written them down.
Yeah. Now, I do know, because we do predominantly a lot of divorce work and a lot of custody work. And so one of the questions people will have is, how do I make sure my spouse doesn't get my children, or the other parent of the children doesn't get our children in death? And you can't X out a parent.
Right. You can't X out a parent. But I would say a lot of people are concerned with, the new spouse too, right? And the new spouse's family and that kind of thing, if there is one, or if there's one in the future. So yeah, it's important to list out those people that you want to be as alternatives. Certainly if you are, you have a kid with a spouse, that person is going to be the first person in line as a guardian. But what if something happens to them? Maybe they're not even gone, like they're not dead, but they're disabled, or they're out of the country, or there's something that makes it necessary to have somebody else in line.
Yeah. And so appointing guardians is something that's really, really important for those minor children.
Yes.
Now, as part of that will, you can also establish something called a testamentary trust, correct?
Correct.
And so how does that work?
So you can also put in a trust in any will that that protects your beneficiaries. So say you have a minor child, you've got this guardian set up for them, and that person is taking care of them, tucking them in at night, physically taking care of them. But you can also have a trustee established and a trust established for that beneficiary to manage the assets, because most people don't want their assets, handed over to a minor. I mean, it's not even really allowed. But you can also make that trust even go longer than minority. Like instead of 18, the trust could go all the way to, 30 or so that you have a trustee in place managing the assets for your children until they're at the age that you decide they are ready to do it themselves.
And so a lot of people will have life insurance policies that will pay into that trust, or whatever other assets are owned.
Right.
And that really allows you to ensure that the money is managed by somebody who's good at managing money.
Right.
And can kind of see the child through their early adulthood, through college,
and that's a good point. I mean, it's not always the same person that's the guardian and the trustee. I mean, sometimes it's, Aunt Mindy is really good at taking care of kids, and Uncle John is the guy that's good with the money. So you can designate all those people and put everybody in their right position to help your family the best way that you think is right.
What advice do you give when talking to people about who they should select as a guardian and as a trustee?
So if you do, I mean, a lot of people are not so lucky that they don't have a million people to choose from. I'm like that. My family, we've got my brother, and that's it. So if you have just one person, they can do both jobs as guardian, and they can also be the trustee. If you have multiple people, I mean, it's just your own personal choice. You want to make sure that they are stepping into your shoes. So you want that person who's the guardian to be, parenting the way that you would parent, or hopefully, close to what you would parent like. And then same thing for the trustee. You want to pick somebody that is going to, manage your assets the way that you want them to, or the way that you would have. Because, the trustee has a pretty broad scope. They can or, for the most part, I would advise that you give them, a lot of leeway on how to manage your finances. They can invest, they can sell things, they can buy things, they can do what they need to do with your assets. And you want them to be doing the things that you probably would have done.
Right.
And so, it's all for the beneficiary of the beneficiary. I mean, it's all for the benefit of the beneficiary. The trustee doesn't get anything out of it. And that's another thing that people ask about, is if they're going to somehow be paid for, doing all this. That's not something that we need to worry about. They're doing everything for the benefit of the beneficiary.
And of course, it's a good thing to have conversations with the people that you're designating as guardian and or trustee ahead of time.
For sure.
Because it's not something, just because they're named in a document doesn't mean that they have to accept those responsibilities, right?
Right. It's not like, this dates myself, but it's the baby boom with Diane Keaton. Nobody just gets handed a baby at an airport.
Right.
That's not what happens. So yeah, you want to talk to people, make sure that this is the right choice. And then I've had people come back, sometimes things change, so you might say, this is the person, now, but, maybe later it's not the right person. Or you have a sibling that, was younger, and now they're older, and you're impressed with how they are as an adult, and you want to make them your person.
Right.
So.
And one of the things that's always been sort of important for us when taking into consideration who we appoint is, geography. Where are they living? Where are they residing?
For sure. People always worry about that. I guess most of us think that it's best if they're local. But, kids are resilient. So if something happens, and the best person for the job is out of state, like, we can figure that out, and, they can move, or, if they have to, the fiduciary can even move. So
right.
You never know.
No, there are lots of transitions. And the important thing is that these decisions were thought through ahead of time by you. And I know that it can make such a difference. When we recently went through the loss of my mom, she had everything done. And so all of her powers of attorney were done. The will was done. The plans for what to do with the body and the funeral, and all of those arrangements were made. And that was such a relief to not be having, in the moment of grief, to be dealing with all of those things.
For sure. And certainly when you have a situation where you have an older person and you have some kind of disease, there's usually time to figure that stuff out. But when you're younger, you don't. And I think a lot of people think, well, this doesn't apply to me. I don't have enough stuff, or I'm not an adult yet, really. It's get it done, get it taken care of, and then it's you can rest easy.
Exactly. And I want to shift a little bit and talk about, death is one situation, but another situation is when you're incapacitated.
Right.
And
we get to talk about fun stuff.
Fun stuff. And so there are some legal documents you can have in place that, again, can make it so much easier for your loved ones to be able to help take care of you and take care of your assets. So let's talk about what those documents are.
Sure. So yes. So your will is great, and it works when you die,
right?
And when it's probated. So that's one scenario. It's really not going to be that helpful if you are still alive, and maybe you're disabled, or you're in a coma, or some kind of catastrophe has happened. So we've got all sorts of documents that cover you for that. Power of attorney is an important document where you designate your agent to make financial decisions for you. And so, in most cases, you think, oh, well, people are just going to do that for me, or even my spouse is they're just next in line. Not necessarily. In the world we live in, there's a lot of privacy and protection. And so, not necessarily your spouse walks into your bank and is able to just get into your accounts. So it's important just to have people listed, like your spouse or your friend or whoever you want to have your agent be, to be able to manage things. And for the power of attorney, you don't even have to be disabled or incapacitated necessarily. You can make it so that it just works if you're out of town, or you're out of the country, or you're unable to do something, you can designate someone.
And even with the power of attorney, that person, depending on the rights and duties that are elected, they can be authorized to do real estate transactions on your behalf.
Right. We can make them specific, but usually when we're doing estate planning, we make them pretty broad so that they'll come into play if you need them.
Yeah.
But yes, yeah, you can make all sorts of different decisions about
And
what your agent can do.
I want to go back and talk about, because when you don't have that durable general power of attorney in place, what happens if you are incapacitated and you're not able to make a decision, then that means the bank can't, like, nobody can just go in and start paying bills on your behalf.
Right.
So those bills go unpaid.
Right. They go unpaid, or someone else is having to pay them, and that's
out of their
huge
pocket,
burden
huge
for them.
burden. Yeah. And the option is to have a guardianship, which is done through the probate court, but is very expensive and very complicated.
And time consuming. It can take for a long time. There's a huge process with, investigation and ad litem attorneys and all sorts of people get involved, because that's not something that's taken lightly to appoint a guardian for an adult.
Right.
So yeah, you want to avoid that. This is, easy paperwork that you just think through a little bit beforehand.
Yeah. And you just need to think, who is the person who I would want going to the bank or going to the storage unit?
Who is my person?
Who is my person who's going to be able to do that?
And, who's my alternate person?
Mm-hmm.
Yeah. You can put a couple people in there.
Absolutely. So that's the general power of attorney, deals with property.
Right.
What's the next power of attorney?
So the next, all the rest of the documents really do deal more with incapacity. So say you're in a situation where you really are unable to make decisions for yourself, and we're talking about your health. So we've got a medical power of attorney, and that is where you appoint an agent to make medical decisions for you. So certainly if you are in a hospital and you are able to, wiggle your finger or blink your eye, to be able to make a decision for yourself, you're making your own decisions. It's, doctors want you to make your own decisions.
Right.
But if you are unable to, you can appoint this person and alternates to help make decisions. So that would be like treatment decisions, things like that. And then there's also a directive to physicians, which is a different document. Sometimes it's called a living will, which I think is confusing to people sometimes, because it's not really something that disposes of your assets like a will does. But a living will or an advance directive says to your physicians how you want to be treated if you are in an end-of-life decision-making situation. So if you are in a terminal condition or an irreversible condition, you're completely out of it, unable to make decisions. That's a document where you can designate, hey, I want to be, given all available life-sustaining treatment, or you can say, hey, I just want comfort treatment only.
Yeah.
So there's those two documents kind of cover, if you're incapacitated.
Do you find that people struggle with that?
Oh my gosh, yes. Yeah. So the medical power of attorney is a little easier because it's just like, hey, this person's making decisions for me.
Sure.
I'm fine. I'm not fine at the moment, but I'm going to be fine. The directive is it's a hard document to think about, because you are in a situation where you're thinking about how you want to be treated. And then also how you want your family to have to make decisions like that.
And these are cases that we'll see in the news from time to time when somebody didn't do the advance directive, and their families are not in agreement on how much life-sustaining treatment should be given.
Right.
And so you can have real battles between.
Certainly. And unfortunately, in practice, there's a lot of people involved, and it should be that way, really, because it's a life. But so you've got doctors involved, you've got the hospital involved, and then relatives. So to me, the very best thing about the directive is that it's just like this. It sounds kind of cheesy, but it's kind of this love letter to your relatives, because at the end of the day, they're there making those decisions, right? They're there having to be awake and watching this situation happen. And they can go back to this piece of paper and say, oh my gosh, mom or dad really thought about this. They thought about it so much that they wrote it down,
Mm-hmm.
and they signed it, and that really can help, like, make people feel better about a terrible situation.
Right. And as I've thought about this, it's sort of evolved over time. And I imagine for many people, it does as well. When you have young children, the worst thing I could think of was being apart from them. And, even if I were in a vegetative state, I remember thinking that at least I would still, maybe see them grow up, not paying attention to the burden that would create on the family to just have mom in a vegetative
Right.
state, non-responsive,
Mom like upstairs in the bed.
right.
Yeah.
Versus really when we walked through the end of life decisions with my mom, knowing that keeping her alive was just for our own benefit was merciless. Like there was a time as her body was kind of winding down with the cancer, it was just time for her to go. And so not having resuscitative treatments made sense. And
Yeah.
so I think, kind of walking that walk and having somebody to talk through those different options with and at different phases in life is a good thing.
Well, and you mentioned it earlier, it's important to talk about all this stuff with your family members. I mean, with the will, with any of these documents, I mean, it's not the most fun conversation, and I wouldn't beat it to death. I guess that's the wrong thing to say. But, don't bring it up all the time, but you can occasionally be like, hey, just, I just finished these documents. Yeah. Here's where they're located, just in case, you know, and here's what, I did. Because there's less complications in the future if you're more open about it. And if relatives are kept in the dark about, who's in charge and who's doing this and how things are going to go, it usually leads to more conflict. So it's better to just talk about what you've decided and what you're going to do, how you want things to go. I mean, even with funeral plans, right? Do you want to be cremated? Do you want do you want a big, huge party? Do you not? All those things are things people just don't know.
Yeah.
And it sucks to have to make those decisions, in the traumatic time.
It really does, because grief is in and of itself overwhelming.
Right.
And it is very difficult to make those decisions. And
it's so much better if it's just laid out.
It's so much better.
You're like, oh yeah, I remember we had that conversation. And oh yeah, here's all the stuff that I need.
Yeah. And really, really the more conversations you have about it, I think the more we can normalize those conversations, the better it is for people. And, I know when you were saying that, I was thinking every time my parents would go out of town, my mom would always say, okay, here's the file, honey, if anything happens to us. And, 999 times we never needed that. But then when it came time, I knew where the file was because we'd gone over it before.
Right.
And so that wasn't a shocker. It was a very normal part of the conversations we were having.
Yep.
And so I think if we can encourage people to have those normal conversations, then it makes end of life a very different experience.
Right. We're not getting out of it.
We're not getting out of it. I know. we were just talking about the documentary on Netflix called Stutz, and he says there are three things that life is made up of. It's pain, uncertainty, and constant work. And it's just part of the normal thing, and we can embrace that and go, oh yeah, all right. Well, the planning I can put in place for the times of uncertainty will make those times of uncertainty more manageable.
And the planning it's funny, it's not even really for you.
Right.
It's your plan, but it's not for you. It's to take care of those people that you love and make it easy for them.
That's exactly right. So there are some touch points in life, I think, when it's really good to come back and visit the estate planning process. What are those points?
So like I said before, when you have a baby, that's a good one. Sometimes I have people call me even before they're going to have a baby. And I think, wow, those people really have their act together. So, and then, if any special circumstances come up, like if you have any special needs with your children or anything like that, you can plan for them. And then, I would say, you can put it all to bed for a while, and then, kids grow up, and then all of a sudden, you're thinking, okay, well now they're adults. And instead of worrying so much about them as minors, now they can start, stepping up and taking care of me.
Right.
So a lot of times that happens when they become adults, or maybe you have some grandchildren come into the picture and you want to change some of your things to take care of them also. Hey, maybe I've done pet trusts, so maybe you got a really good dog that you want to leave something to. It's possible.
It is. There are some very, very expensive pets out there, both in the world of divorce and in the world of estate planning.
But yeah, and then of course, unfortunately, if you get divorced, that is a time when you want to take a good look at your documents.
Yeah.
Certainly the power of attorney, those
Really,
things you
at the
don't really
beginning.
probably want your ex or the person you're in a dispute with. Yeah, even if you haven't gotten divorced yet.
Yeah.
You want to make sure you revoke those people if you have them listed. Because you probably don't want them making decisions for you.
Probably not.
And then let's see what else. If some huge major, asset thing changes with your life, like you win the lotto, maybe you inherit something really major. That's a time sometimes to look at your documents again to see if you need to change things for tax purposes or.
Exactly. And one of the things that we talked about is there's sort of the basic estate planning, which are the will and testamentary trust and the documents that we're talking about. There's also more sophisticated estate planning. So if your assets are over 25 million as a couple.
And some change. As a couple. For an individual, it's 12.92 million.
Okay.
So if your estate is under that amount, and that includes everything. So all of your assets, your real estate, your cash, your bank accounts, stock portfolios, also even your payouts on life insurance.
Okay.
And things like that, retirement accounts. So if all of that is under that 12.92 for 2023, it changes kind of every year. Mainly it goes up. It's just like indexed for inflation.
Sure.
But if you're under that amount, then you don't have to worry about being taxed.
Your estate being taxed.
Your estate being taxed.
But you do want to make sure that the assets are properly identified as beneficiaries or designated and so forth, because we've seen some situations where there have been significant tax implications, even if you're under that threshold, if it's still not done correctly.
Right.
So.
Yeah. And that's, we can get as complicated as we want to. But generally, most people just really need a pretty simple, straightforward estate plan. It doesn't have to be scary. We can walk right through it and get it all done. And then, it's kind of we will revisit it sometimes, like we just said, but for the most part, it's, you get it done and then you just don't have to think about it for
And it really is
time.
Peace of mind to have that done and to know that your loved ones are going to be taken care of in the event of your death.
And my job is to think about all that. That's why you hire an attorney, because, they think about, the future. And my job is to make it so that this is not something you have to look at a ton.
Yeah.
We want to make it so that it lasts and it works.
That's great. And one final thing I'm going to touch on. And so, of course, we're talking today usually to adults who have jobs and families and children. But when our children become adults, this is also a really good time to make sure you have the proper documents in place for that adult child.
Oh yeah, that baby 18-year-old adult.
And so where the school will no longer give information about their grades, and the doctors will no longer talk to you about their health care.
Right.
And so what are some of the things that we recommend with regard to the adult child?
Certainly, I would say you would want to get a power of attorney in case you need to help them with their finances at any point. A medical power of attorney, like we talked about, a directive. It's sometimes a little bit hard to talk about end-of-life decision-making to an 18-year-old because they are
invincible.
But it's a thing. If something happened, maybe in certain 18-year-olds want to think about it. And then the HIPAA authorization, and that's something that we forgot about earlier. I would recommend that for everyone. Everyone knows when you go to the doctor, you fill out that privacy notice and the HIPAA authorization. every time you go to the doctor. But we can do a general one that just covers you for any circumstance. So maybe you're taken to a doctor you've never been to because you've been in an accident or something.
Yeah.
And you can, again, say in there, who you want to have access to your information. And I would say every adult needs that also.
Yeah. And also a lot of schools, there's the Federal Education Act, and this is a conversation to have with your children. But if you are expecting to have access to the grades, they're going to need to fill out the FERPA form, FERPA, which will allow the university to communicate with you about the grades. So I got to learn about that as well. And it's important to have all those documents in place.
Yeah, I mean, you don't want to take away their, independence and autonomy, but you're still going to be helping, and you're paying the bills most likely.
Right.
So,
and the way I really approach it with my adult children now is that this is an important decision that they're making as an adult. And so, it wasn't, here are all the forms that mom prepared, you have to sign.
Absolutely.
It was, here are the legal forms, and here's what they mean, and really breaking it down with them and helping them understand.
I mean, they are the client.
Yeah,
we can't do what parents want them to do.
Right.
I guess if they wanted to list somebody else, they could.
They could. Yeah. And if they want to revoke it after they
right,
they can do that too.
Yep.
Well, I want to thank you for taking time to come and talk with us about this very important topic. And if you want to learn more about Mary Glenn and her practice at Hargrave Family Law, we'd love to have you check out our website where you can read all about her and schedule an appointment to come in and get your estate planning done. You'll feel so much better when you do. So thank you.
Thank you.